Easement. The sunken property is lower in elevation than the Vergara property, and thus it is legally obliged to receive the waters that flow from the latter, pursuant to Article 637 of the Civil Code. This provision refers to the legal easement pertaining to the natural drainage of lands, which obliges lower estates to receive from the higher estates water which naturally and without the intervention of man descends from the latter. That is, not those collected artificially in reservoirs, etc., and the stones and earth carried by the waters. Article 637. Lower estates are obliged to receive the waters which naturally and without the intervention of man descend from the higher estates, as well as the stones of earth which they carry with them. The owner of the lower estate cannot construct works which will impede this easement. Neither can the owner of the higher estate make works which will increase the burden. In this light, spouses sunken should have been aware of such circumstance and accordingly made the necessary adjustments to their property so as to minimize the burden created by such legal easement. Instead of doing so, they disregarded the easement and constructed their house directly against the perimeter wall, which adjoins the Vergara property. Hence, there was contributory negligence. Verily, contributory negligence is conduct on the part of the injured party, contributing as a legal cause to the harm he has suffered, which falls below the standard to which he is required to conform for his own protection. Spouses Vergara versus Sunken, GR 193659, June 15, 2015. Is an agreement on easement binding upon the parties and their heirs? That the heirs or assigns of the parties were not mentioned in the annotation does not mean that it is not binding on them. Again, a voluntary easement of right-of-way is like any other contract. As such, it is generally effective between the parties, their heirs and assigns, except in case where the rights and obligations arising from the contract are not transmissible by their nature or by stipulation or by provision of law. Article 1311. Petitioner cites City of Manila versus Entote, L 24776, June 28, 1974, in justifying that the easement should bind only the parties mentioned therein and exclude those not so mentioned. However, that case is inapplicable since the issue therein was whether the easement was intended not only for the benefit of the owners of the dominant estate but of the community and the public at large. In interpreting the easement, the clause "any and all other persons whomsoever" in the easement embraces only those who are privy to the owners of the dominant estate and excludes the indiscriminate public from the enjoyment of the right-of-way easement. Unisource Commercial versus Development Corporation versus Chung et al. GR 173252, July 17, 2009. What about a permanent easement? Will it survive termination of necessity? When the easement in this case was established, the parties unequivocally made provision for its observance by all who in the future might succeed them in dominion. So it is permanent in character, which was annotated on each and all of the transfer certificates of title. Even assuming that with the demolition of the house by the owner, the necessity for the passageway ceased, still, such fact does not detract from its permanency as a property right which survives the termination of the necessity. It is true that the private respondent is the owner of the portion on which the right-of-way had been established, and that an easement cannot impair ownership. But the petitioner is not claiming the easement or any part of the property as its own. Rather, it is seeking to have private respondent respect the easements already existing thereon. Benedicto versus CA. What is the reckoning period in computing the acquisition by prescription of a positive and negative easement? 1. In a positive easement, The period shall be computed from the day the owner of the dominant estate or the person who made use of it commenced to exercise it upon the servient estate. 2. In a negative easement, the period shall be computed from the day the dominant estate forbade, by an instrument acknowledged before a notary public, the owner of the servient estate from exercising an act which would be lawful without the easement. What is the effect of the existence of an apparent sign of easement? Under the provision of Article 624 of the New Civil Code, the existence of an apparent sign of easement between two states, established or maintained by the owner of both, shall be considered should either of them be alienated as a title, in order that the easement may continue actively and passively, unless at the time the ownership of the two estates is divided, the contrary should be provided in the title of conveyance of either of them, or the sign aforesaid should be removed before the execution of the deed. This provision shall also apply in case of the division of a thing owned in common by two or more persons. Example of this rule is a case where there is an apparent sign of the existence of an easement of light and view involving two estates originally owned by one and the same person. This is indicated by the doors and windows of the house in the southern portion overlooking the northern portion. The sign was established by the original owner. The southern portion was subsequently alienated to Y and the northern portion to Z. Furthermore, nothing contrary to the easement was stated in the deed of conveyance. Neither was the sign removed. Therefore, the easement of light and view shall now be protected by law. Z cannot construct his building unless he complies with the 3-meter rule as provided by law. See Gargantos versus Tan Yanon, 108 Phil 888. Reason: easement is inseparable from the state to which it belongs. Where should easement be established? Where there are several tenements surrounding the dominant estate, and the easement may be established on any of them, the one where the way is shortest and will cause the least damage should be chosen. The conditions of least damage and shortest distance are both established in one tenement, which is the petitioner's property, Santa Maria versus CA, GR number 127549, January 28, 1999. Alicia Reyes versus Spouses Valentin, GR 194488, February 11, 2015. There must be a proof that the easement must be established at a point least prejudicial to the servient estate. If the servient estate is only 164 meters, an improvident imposition of the easement on the lot may unjustly deprive the owner of the optimum use and enjoyment of the property, considering that it's already small and it will be reduced further by the easement. Worst, it may even render the property useless for the purpose for which it is intended. Cristobal et al. Versus CA et al. GR 125339, June 22, 1999. What are the requisites of easement of right-of-way? The owners of the dominant estate may validly claim a compulsory right-of-way only after they had established the 4 requisites under Articles 649 and 650 of the New Civil Code, to wit: 1. The dominant estate is surrounded by the other immovables and is without adequate outlet to a public highway. 2. After payment of proper indemnity. 3. The isolation was not due to the proprietor's own acts. And 4. The right-of-way claimed is at a point least prejudicial to the servient estate. La Vista Association versus CA et al. GR 95252, September 5, 1997. Cristobal et al. Versus CA et al. GR 125339, June 23, 1998. And again, if you're not yet subscribed to me, Please hit that subscribe button. It's free, and you get notified with all of my audios. If you have any feedback or suggestion, inbox me or leave me a comment. Thank you.